Pollack?
May it please the Court, the issue presented in this case is the balance between two long-standing, protected, yet competing interests. The first interest is that of the next of kin, the long-standing right of the next of kin to the remains of a deceased loved one for a proper burial. It's that interest against the interest of society to investigate certain crimes and public health risks. And that interest has been entrusted to the medical examiner's office. The law has long recognized the next of kin has a right to the remains of the deceased. In fact, some cases have even determined it as a duty of the next of kin to properly handle the remains in the body of a loved one. Massachusetts General Laws, Chapter 38, Section 3, in certain...
I have a question. Was the issue of qualified immunity brought up before trial, i.e. by a motion for summary judgment?
Yes, it was, Justice, and it was denied. It
So
was brought up by the defendant in the case, and it was
and
denied.
it's denied, okay, all right.
And wasn't there an interlocutory appeal taken from that?
There was not.
There was
No
not,
interlocutory
okay.
appeal taken.
So how do we balance things when sometimes the organs have to be kept for a long period of time in order to study and examine them?
Well, I think that's an important question. I think we balance that by determining, still looking at the purpose of the statute, which is researching and investigating specific cases of crime or public health risk. If the retention of an organ is specifically in furtherance of one of those enumerated policies, crime or public health risk, then the retention of organs would be proper. Outside of that specific authority, then the medical examiner or any designee working under the authority of the medical examiner does not have the right to keep the organs in perpetuity. And that's really the problem. That in this particular instance...
But there's nothing in this case that suggests that those organs were then shipped off to some place for research, for some unrelated research. I mean, they were preserved at the place where the autopsy took place, correct?
Absolutely. And I concur that...
And if they were preserved in the reasonable belief that they might provide or shed some insight into whether or not a crime has occurred here or whether the cause of death is something that needs to be investigated further, why isn't that sufficient? Why isn't that the end of this case?
Well, the initial part of your question, in furtherance of a crime, I agree with.
Right.
The second part, to simply do an academic or scientific analysis to determine cause of death, that is not within the scope of the authority of the medical
Why
examiner.
not if it's a matter of public safety or potential public safety? Here, the child died shortly after being vaccinated. Why isn't that exactly the kind of thing, that's the kind of death that needs to be investigated? Why isn't it?
I think if there can be something learned and there's any evidence in the case that retaining an organ can provide any assistance or any knowledge for a vaccine-related death, if we want to talk about the specific death in this case, then I would concur. But there was no evidence in the entire case that there can be any specific knowledge gained or any specific purpose from taking whole organs to determine a vaccine cause of death.
What about the idea of comparing one set of organs with other organs that may come in over a period of time?
You mean keeping a whole organ in case they
Yeah.
need to go back to it?
Yeah, so that if you have a pattern that develops over a period of years, you've got the organs there and you can compare to see if they're the same as other people who suffer from the same problem.
I think we return then now to the balancing to keep in mind the interest of the next of kin and weighing that interest. I think taking slides in the right instances and keeping blocks of the slides to make sure that they have proper slides to be able to do whatever pathology or toxicology they need to do. But there's no reason to keep the entire organ, and that's what we're talking about
Mr.
here.
Pollack, can I interrupt you?
Absolutely.
It seems to me that the legal issue that we confront is whether this case should have gone to the jury in the first place. If we conclude that it should have gone to the jury, you lost in front of the jury, correct?
That's correct.
So on what conceivable basis do we reverse a jury determination, even assuming that we decide that this was properly submitted to the jury?
I think if we look at the way the case, my ability to present this case initially, the plaintiff brought a motion in limine to this court, the lower court, asking for instructions on this statute, recognizing the potential problem
I
that was going to
understand.
develop in the
Tell me
trial.
specifically where the jury instruction is incorrect, or what you have to point out some error in the trial court.
Absolutely. The instruction that the statute allows for the medical examiner or his designee to do whatever is reasonably medically necessary.
And what is wrong with that instruction?
That in and of itself potentially is not a problem. The problem with it, it implies that they can do whatever is reasonably medically necessary to determine a cause of death, taking aside the original
of
purpose
course
of the
they ha-
statute.
that's-
Did you have an expert witness that said this wasn't reasonably necessary?
Specific to that point, Your Honor?
Yeah.
We did, absolutely.
And he said this, or he or she, what was it, another doctor? Another
It was
pathologist?
another doctor, it was another
What was
medical
the evidence
examiner.
as to why the organs were retained?
What was the evidence as to why they were retained? The only evidence that was offered as to why they were retained was in case they needed to be gone back to for another reason, in case someone needed to go back to the organs themselves, they didn't get a good slide originally, or they wanted to do some other purpose. But there was
Wasn't
no
it
specific
related to the
purpose.
possibility of either SIDS or the diphtheria shot?
The answer to that is no. There was nothing specific to this child's cause of death that related to why they were keeping these particular organs. It was a general blanket excuse that was offered, just in case we need to go back to them for some reason whatsoever.
Forgive me, Mr. Pollack. I have to have you focus. What was improper about that instruction?
And I apologize. I want to finish the answer. The answer was that alone in a capsule did not sufficiently describe. To say whatever is reasonably medically necessary to determine cause of death, it needs to be still in furtherance of the interest that is authorized by the statute, which is public health risk or
What was the
crime.
jury instruction that you requested?
Where is it?
Yes.
It's in our brief. I believe it's the second question that's presented.
No, I see the question.
So did the judge,
I think it was question number, I think it was instruction 15, if I'm not mistaken, on the
so the
record.
judge
But
instructed?
what is that? What was the instruction that you were looking for?
Once we learned that the judge was going to interpret the statute to provide reasonably medically necessary, we said that still needs to be
I
retained
know. What
within
did
the
you
authority.
ask the judge
So
to?
we asked the judge to make sure that they said whatever is reasonably medically necessary in furtherance of the original statute, public health risk, or crime. You simply can't do an academic or scientific autopsy.
So didn't the judge
to
talk about
determine
the
the
statutory
cause?
criteria?
No.
At all, never.
It said
Never
she-
talked about public health risk or
Excu-
crime.
Excuse me. To determine the cause of the decedent's death, you may have had a better instruction, because to determine whether or not a crime has been committed, you need to determine the cause of the decedent's death. To determine whether or not there's a public health risk, you may not need to determine the cause of the decedent's death. Right?
Yes.
This judge instructed, as I understand it, whether or not the scientist, the doctor, the pathologist did what that he or she reasonably believed is medically necessary to determine the cause of the decedent's death. That surely meets the crime prong.
There was never a consideration of crime in this case. That was ruled out upon examination of the body.
But you guys argued it to the jury, the point you're now talking about. The judge says, the statute says reasonably medically necessary. Well, I'm reading the instruction. During argument, there was a question about what does that, meaning reasonably medically necessary, include? You can do this, you can do that. So the judge says, well, you know, you've heard these two people, these two lawyers argue about what was reasonably medically necessary. So he clued him into that. Isn't
But
that permissible?
specifically as it pertained to the authority, government, that's what we're talking about. How far can they go with this autopsy? Do they have a right to do whatever they want to determine the cause of death?
Yes. Because
Even if
that's
that death is not in furtherance of a crime or a public health risk?
Well, how do
Our
you
position is that they can't. It stops at that
As
point.
I
and the interest is
understand
next
it, you
of
have
kin.
to keep the brain for a week or two in formalin. I assume that's a form of formaldehyde for it to settle, or whatever the medical word is, before you can do an adequate examination of the brain for toxic substances. Wasn't there testimony to that effect?
Absolutely.
Yes.
the judge did refer to the statute.
The judge referred to the statute but did not explain the statute, did not interpret the statute to include the authority that was governing the autopsy to begin with, which was whether or not there's suspicion of a crime or public health risk. That's the reason the medical examiner was involved in the first place.
Mr. Pollack, I don't want to argue with you, but it is for the person conducting the autopsy to determine the cause of death. it is not for the person conducting the autopsy to determine whether or not there was a crime. For example, somebody may have suffered death caused by 5 stab wounds. Whether or not that constitute a crime is a separate issue. It seems to me that the legislature has said you have to find out the cause of death because it might constitute a crime or it might constitute a public health risk, but you have to determine the cause of death.
If there is a concern about a particular crime or a public health risk, and the retention of organs is in furtherance of that, then I would agree. But if the retention of organs, and that's what we're talking about in this case, the unconsensual retention of organs is done and is not in furtherance of any public interest, then what purpose is it serving by allowing the medical examiner, without consent or his designees, to retain those organs when it was not in furtherance of the original purpose of the statute? That unfettered authority goes beyond the intent of the legislature when they enacted the statute. And all the legislative history and all the cases speak directly to that point. There's never been a single case.
And that's what you argued to the jury.
I never got to argue that to the jury. We were precluded from arguing our interpretation of the statute. I asked in the motions in limine, Justice, if we could be allowed to have the interpretation of the judge at the beginning of the trial. Let us have your understanding of this statute. Tell me how you're going to interpret. Therefore, I can offer evidence to this jury consistent with that. The judge denied that. Even though the judge said that it would be of great assistance to us, he denied that motion in limine. So we didn't learn until the end of the trial what the judge's interpretation of the statute was going to be. And I say that was a prejudicial and reversible error.
Okay.
It is the authority here that we're challenging. How far can we go? My concern, Justice, is if we go to the extent of the amicus briefs of the Attorney General, if we go to the appellee's point of view, then it is unfettered authority. They can do whatever they want. They can simply work under the blanket of we are working under the medical examiner's
There's
authority.
That isn't your
Suggestion.
case. We're here on your case, I thought.
Excuse me?
But that's not your case.
It is our case. They were the
No,
evidence in this case is
They
that.
returned the organs within a relatively short time.
Very good point. The only reason those organs were ever returned was because it was learned by the plaintiffs that they had retained them. Otherwise, there is no evidence that the plaintiffs would have been provided any notice of the retention or that the organs were going to be returned at any time. That's what's concerning here. That slope to allow Children's Hospital or the medical examiner in any autopsy which is authorized by the statute to retain organs without notice and retain them indefinitely without ever returning them, that act alone violates Section 13 of Chapter 38, which says the body needs to be returned upon completion of the examination. Clearly, once the pathology report came back and the toxicology report, even if you find that it was somewhat reasonably medically necessary for a shortened period of time, they had an obligation to return the organs at some point. And that never happened. Only when the plaintiff requested they be returned, when they found out on their own initiative. Otherwise, there was no evidence they were going to be returned at any time.
Mr. Pollock, do you wish to address the public employee point about whether or not they're entitled to immunity?
Well, I think the only point being raised on this appeal was that the jury had answered that question. In our reply brief, we addressed it by saying that that violated the instructions of the court.
No, I understand that, but do you have a position?
Our position is that it was clear from all the evidence in the case that all of the pathologists and doctors working in this case at Children's Hospital were not working under the orders or control of the medical examiner. They came into this autopsy at the request. Once the medical examiner left the autopsy room, the medical examiner was finished with their autopsy at that point. Whatever Children's Hospital did it after that, they were working under their own protocol.
May I just ask you this? Did you challenge the judge's instruction on of public employee?
Absolutely.
You did challenge it?
Absolutely. It was part of the transcript that we stated to the judge that, first of all, the first argument was that it was implicit within the decision of the jury themselves, meaning that we wanted that jury to ask whether or not they violated the statute. The instruction came down as whether or not they were negligent. It was our position that if you find that they were negligent, then they exceeded the scope or the authority of the statute. Implied within that is that they're not immune, because the law is very clear. If you exceed the scope of the authority provided to you by statute, then you're not governed by immunity. You don't get that cloak. The same holds true, that if you find they were not negligent, that they were properly within the confines of the statute, then you will find that they were acting as public employees and they should be granted immunity.
On appeal, did you challenge the judge's instruction?
On
Appeal, on...
we did not challenge that instruction.
Okay.
Absolutely not. I would like to point out that, getting back to when the medical examiner left the room, the evidence from the medical examiner is that in medical examiner cases, they do not uniformly retain all organs. That is not their policy, that is not their protocol, because it is not necessary. When the medical examiner left that room, Children's Hospital was working under their own protocol, not under the statute of the medical examiner, not under the authority provided by the legislature. And it was that protocol that Children's Hospital was following that I believe violated the rights of the next of kin.
Thank you, Mr.
Thank you
Potter.
very much.
Mr. Daly?
Thank you, Your Honor, and members of the court. I represent the Children's Hospital and the 3 physicians who conducted the autopsy. David Macrelli died on September 11, 1996. It was 18 hours after he had received a DPT vaccination, and the tragic death of the child was unexplained. The medical examiner, as he was required under the provisions of Chapter 38, the child being under 2 years, had to take jurisdiction over the autopsy. A request was made to Children's Hospital to perform the autopsy, and this is done from time to time, perhaps 2 to 3 times a year with Children's Hospital, but many, many times with the various hospitals that are in the Boston area and beyond. Basically, these hospitals are providing expertise where the medical examiner does not have the capabilities or the resources to perform these autopsies. There was a stipulation at the beginning of the case, and the stipulation was as follows. The autopsy was a medical examiner-ordered autopsy and required no consent from the decedent's next of kin, and the Children's Hospital doctors were required by law to assist the medical examiner. Now, there were a number of facts that were not in dispute at any time during the case. The fact that the medical examiner was required to perform the autopsy, that the defendants were required to perform the autopsy when requested to do so, that the autopsy was performed under the authority of the medical examiner, that it was performed at Children's Hospital to take advantage of Dr. Kinney's expertise with regard to sudden infant death problems, that the medical examiner representatives supervised the autopsy. As a matter of fact, 2 of the pathologists from the medical examiner's office were present and were working shoulder to shoulder with the 2 children's physicians during the autopsy.
But they did leave before the autopsy was completed, did they not?
Right, just before, Your Honor, that's right. But you'll see from the testimony that Dr. Curry was deceased, but both of these doctors had indicated they fully expected that the organs would be retained after an autopsy of this type in order to complete the studies that were necessary to try to determine the cause of death.
Yeah,
Did they-
and didn't they issue a preliminary report in anticipation of further toxicology and other tests that would be forthcoming at a
That's
later
right.
date?
That's right. The autopsy was performed on September 11. The body was released on September 14, and the toxicology reports didn't come back to October 8th. So there was a good lapse of time there. And then there was an indication that Dr. Kinney and Dr. Lipman had both advised the mother that this study would take a long period of time because of the SIDS component and the fact that the work with the brain does take a long time because of the fixation problems and the need to study the brain.
So was there evidence that the parents had been notified that although the body was returned, some organs were retained?
I don't know that, Your Honor. I don't think that was so, but there was the statement that this is going to take a long period of time to try to determine the cause of death. Both Dr. Lipman and Dr. Kinney both testified to that.
Do you know what typically happens after organs are retained? Is somebody, are the next of kin typically notified when the body is released that it's not the complete body, or do they receive notification at a subsequent date that the organs will be returned? And are organs always returned?
Organs are not always returned. Depending upon the conversations that take place with the next of kin, there may be a discussion. Normally, that discussion would take place between the medical examiner's office and the next of kin. In other words, for communications reasons and not to have two sources of information being sent to the parents. It's normally handled through the medical examiner's
Well, we got a
office.
regulation on it now, don't we?
We do. And the
That came about after this case.
That's right, and I think it would address Justice Spina's question. The law, and you'll notice it's under 105 CMR 103, dealing with hospital licensure. And it specifically provides that hospitals are not controlled by, as to autopsies that are performed under Chapter 38, except with regard to the fact that next of kin have to be advised if organs are being retained, and there has to be some notification when the organs are through.
The term advised, I assume, would mean you just have to tell them. They can't withhold their consent.
No, I think when you're getting ready to release the organs, in other words, when the use of the organs is complete, you have to advise the next of kin and receive their input into what you want, what they want to do. That's the law
Right,
now.
but they couldn't say, if you're, when you're notifying them in the beginning that you're going to retain them for
That's
some
what I
period
thought
of
it meant.
time, they couldn't say, oh, no, you're not.
No.
Okay.
And as a matter of fact, you'll see that by the very definition of autopsy under 105-130, the autopsy is defined to include the removal of organs. So it's anticipated that the autopsy is going to include the removal of organs and the examination of organs as necessary to try to determine the cause of death.
Mr. Daly, may I ask you this? Because it had, I don't think it was dwelt on very at any length. Chapter 38, Section 13, provides after investigation or examination by the office of the medical examiner, the body shall be released to the person with the proper legal authority to receive it. Is there anything to suggest what the body means in that statute? And let me explain. Obviously, there's a powerful interest, as must have occurred in this case, to release the body as soon as possible, so that the burial can proceed. And as you know, for some religions, a length of time can be, quite, not burying the body immediately can be quite problematic. Presumably, in the course of an autopsy, there are, as we see from the amicus brief that have been filed, the body consists of many things, including organs. Is there anything to suggest that in using the term the body shall be released to the person, that meant a body exactly as it was received, which, as I understand it, would have been impossible?
There's nothing to suggest that, Your Honor, and I think that's the answer. Would literally be impossible to return the body if you're going to do an autopsy in the condition it was received. Here, if I could just mention, there's no suggestion that the hospital and the doctors did not have the right to remove the organs. There's no suggestion that we took more organs than were needed to try to determine the cause of death. There was no suggestion at all that we ever acted in bad faith and exceeded in some fashion the rights that we were given as the surrogate for the medical examiner. And certainly, these organs were not retained for donation purposes or tissue collection purposes or research or academic purposes. There was never, for example, a article published about this. To the contrary, it was an autopsy that was performed, everyone thought, strictly in accordance with the directive we had received from the medical examiner.
And the issue of what is the cause of death can take quite a period of time to ascertain.
It certainly
I mean,
can.
you read about, movie stars and actors and actresses, dying. Heath Ledger was just the one most recent. And they did the same kind of autopsy, and it took a month or two before they could figure out what he died of. It was
I think
correct?
maybe more relevant is the discovery of HIV/AIDS, where they went back for specimens that had been retained for 7, 8, 9, and 10 years to go back again. My point is, it feels more dramatic, but when you talk about an organ, it could be a brain, it could be a liver, it could But in fact, for ongoing reasons, it may be necessary to retain parts of the body. And my question is really is a statutory one, which is when it says the body shall be released, what did the legislature intend? It could not have intended that the body in the form in which it had arrived immediately after death for the autopsy was the same as what is returned.
That's right, and you can see from the amicus brief submitted by the Attorney General and from the National Association of Medical Examiners that it is literally impossible to return the organs with the body if you're going to do your job.
How do you respond to the plaintiff's claim that there's simply no limitation? It gives them unfettered discretion, I think was the term that he used, unfettered discretion to do in essence whatever they want.
Well, that issue has never been raised, that we exceeded our bounds and took more organs than were necessary. That was never a suggestion in the case, and no one ever suggested that. No expert ever said that.
The suggestion was that it was time, that but for Mrs. Macrelli finding out that children still had these organs, children probably would have kept them forever, or wouldn't have returned them to the Macrellis.
If you were to think of the situation, here there were concerns about the vaccination. That could be addressed fairly quickly. They tested the batch to make sure other children didn't get it. That was a public health issue. But there were organs that were overweight, and there was concern about what had caused that. There was concern whether or not, from a public interest standpoint, public health standpoint, whether this was a so-called SIDS death.
Right.
Now, in this state, the number of SIDS deaths has been reduced from 100 a year on average to about 25 because of the work that Dr. Kinney and a couple others have been doing. So there's a great public interest in this issue.
Is there anything in the record, though, to say that but for this serendipitous communication between the Macrellis and the doctor in January, I think it was, that but for that Children's at some point was going to return these organs to the Macrelli family?
There is nothing in the record, Your Honor.
That was the import of my question, which is implicit in the claim here is that there was an obligation to return those organs. I'm not saying that that's correct or incorrect. I'm simply trying to ascertain the source of that, because it is impossible to return the body in the same condition as the body was. So that then the issue, it seemed to me, and the instruction was, if it is necessary to remove the organs and to retain them, or to remove the organs, what is the obligation to return organs after the body has been returned?
Well, the obligation is covered now by the regulations, Your Honor.
Now it is.
Which specifically says, and certainly Children's Hospital and other hospitals are adhering to that regulation.
Certainly, and I assume, because there hasn't been a challenge that I'm aware of to that regulation, that regulation is consistent with the statute.
Right, right. Now, I would just like to point out...
Could I just ask you a question? I'm sorry, but was there evidence that the organs were kept in this case because of concern about the organs being overweight and concern whether this was a SIDS death?
Yes.
And that was the evidence that was why the organs were kept?
Testimony on both scores, Your Honor.
Okay.
Well, that's critical, isn't
Yeah,
it? Because if it's
yeah.
not related to the cause of death, if they're just keeping them, if they know the cause of death is AIDS, for example, and they say, well, we're doing a general scientific study on AIDS, so we'll just keep these things. You can't do that without consent, right?
Right. And then you have a jury finding of no negligence. Then you have a jury finding of no negligence also
Right.
on top of that,
Right, and the jury heard all
with
of
evidence
this.
to support it.
And was it argued to the jury in final arguments? Because the judge in the instruction seems to say you've heard both lawyers on this issue of the retention for cause of death. Was it argued by both sides?
Sure. This was discussed all during the case, and Dr. Kinney was asked many questions about the reasons for keeping the organs and the fact that the brain is an organ that is normally kept for 6 to 12 months for study purposes in order to try to determine whether it's a SIDS death or not.
Mr. Daly, could you address the immunity question?
Yes. The two doctors who performed the autopsy and Dr. Kinney, who was involved, literally worked side by side with the medical examiner's representatives. There is no question that the medical examiner pathologist would be entitled to immunity. Our doctors were designated and required to perform the actions that they did. As the Professional Law Foundation's amicus brief points out, it is essential that professionals who are basically conscripted to perform the duties that they are required to do should enjoy the same immunity as public employees.
But a motion to get immunity was denied, wasn't it?
It was just the summary judgment, but
Summary
it was a jury question.
Yes, but the motion, you did file a motion for summary judgment on this issue, am I correct?
Twice.
And
And
you didn't, but you didn't take interlocutory appeal.
We didn't. No.
Have you waived that? by
No.
not taking
No, I-
interlocutory appeal?
No. but
Comes
we-
an affirmative
we felt-
defense.
We felt very strongly that we should have
Well, it is waived.
had that,
Was
it?
that allowed as a matter of law. And the Professional Law Foundation's brief points out that
You're out of luck.
if we can
Don't think
resolve
so.
this
Yes.
issue early on, it's going to save an
Was
awful
it
lot.
decided by the jury?
No, the judge. You
No,
mean the
no, I know
summary
it, but
judgment?
did the jury pass on immunity at all?
Yes,
Well,
but
yes.
they answered the question improperly, that's the
Oh,
problem. Well, the question, I read the jury verdict, it says if you find for the plaintiff, for the defendants on 1, 2, and 3, don't answer any more questions, and then they did answer the first question.
They answered that question, but if you look at the judge's instruction, he basically invited them, for completeness sake, to take a look at that question.
And what
But
was
then you
their,
should have stricken that
What was
instruction
their
on the
answer?
verdict slip.
That we were public employees. So
Okay,
basically,
fine.
we were
So the
entitled to
issue's-
immunity. It's
yeah.
entirely, whether it was gratuitous or
Yeah,
not,
it
Your
was
Honor,
gratuitous.
it's entirely consistent with our position that we're entitled to immunity.
Thank you, Mr. Daly.
Thank you.
We'll take a short break.